Today we will talk about burglary. Burglary, according to Penal Code 30.02 small a, can be committed in one of three ways. And when we talk about burglary, we're talking about burglary of habitation and or burglary of a building. Another interesting aspect that arises frequently, the individual who gives the consent for an individual to enter into a premises, that individual must be legally in a position to give effective consent. A perfect example of that would be, for instance, a motel owner. An individual comes and wants to go into room 12. That room belongs to someone else who is not present. The motel owner then permits that individual to go into the room. That motel owner is not in a position to give effective consent to enter into a locked room that is occupied by a third party. That third party is the individual who did not give effective consent to the individual intruding into the room or of the hotel. It must be an enclosed structure. That is, the building that is entered into must be enclosed. It cannot be, for instance, a piece of property that is fenced in. However, a portion of the property may be fenced. There can be, for instance, 3 walls and a fence behind. That constitutes and could constitute sufficiently a building, a premises that is necessary for the individual to be accused of going into that premises without the effective consent of the owner with the intent to commit a felony or theft. How about at night? A burglary of a habitation, for instance. If there is a breaking or an entry without the effective consent of the owner at night, then there is a presumption that a nighttime entry is without the effective consent of the owner. So that basically brings the issue of nighttime, leveling out the issue of presumption that exists if the entry is made during the evening hours. This is another area of common interest. An individual must, at the time of the entry into the building or habitation, must, without the effective consent of the owner, must have the intent at the time the entry is made to commit a felony or theft at the very time that it happens. For instance, if an individual enters into a building and does not intend to commit, for instance, arson at the time that entry is made without the effective consent of the owner, is that entry a burglary of a building and or habitation? Case law substantiates the fact that the intent to commit the felony must exist at the time the entry is made. The burglary of a building is a lesser included offense of burglary of a habitation. Burglary of a building carries with it a state jail felony, and burglary of a habitation carries with it a second-degree felony. Let's say, for instance, that an individual commits a burglary of a habitation with the intent to commit a felony other than theft and or felony theft, and be it attempted or actual theft. If another felony is involved, that can easily rise the level of the degree of the felony to a first degree. For instance, an individual breaks into a habitation with the intent to commit aggravated sexual assault. That is a felony, unlike theft or attempted theft. and that would easily give rise to have that individual prosecuted as a first-degree felony.